Hello dear students, welcome to Bajirao Ias Academy interview guidance program. So in this session we will be discussing about the collegium system, which is appointment of judges in both High Court as well as the Supreme Court. Okay, so collegium system is continuously in use, and the collegium system has also been criticized as a system or as a machinery which appoints judges. Okay, so or it is judges appointing judges. Okay, so there's no involvement of legislature or executive in the appointment of judges. Since it has lack of transparency and accountability, the collegium system has often been criticized. So in this context, it is very important for us to understand the collegium system in detail. Okay, so firstly you need to understand what is collegium system in the Indian judiciary. Now if you look at the Indian judiciary, judges of the Supreme Court and High Court are appointed by the judges. So in this context, the collegium system has been criticized as a machinery which through which judges appoint judges. So in this system there is lack of transparency. Okay, so in collegium system, or the collegium system is actually a system in which the appointment or transfer of judges of Supreme Court and High Court is done through this system. Okay, so actually the collegium system has it does not have any constitutional sanction. So there is no provision which says or which grants the collegium system. So however, the collegium system is a judicial innovation similar to the basic structure doctrine that was invented by the judiciary in the Keshwananda Bharati judgment 1973. Okay, so however, the collegium system has actually evolved through the judgments of the Supreme Court. So you may have heard about the first judges case, second judges case, and the third judges case. So these are the important cases through which the collegium system has been evolved over a period of 20 years. Okay, so in this context or under the system of the collegium system, the Chief Justice of India along with 4 senior most judges of the Supreme Court recommend the appointment or transfer of judges, right? So the collegium at the higher level, or the collegium which consisting of Chief Justice of India and 4 senior most judges of the Supreme Court, actually recommend the appointment and transfer of judges in high courts. Okay, now in this context there's also a High Court collegium which generally appoints or transfers judges at the lower levels or district levels. So however, the High Court collegium actually comprises of the incumbent Chief Justice of the respective High Court. So whatever High Court it may be, the present Chief Justice of the High Court and 2 senior most judges comprises the collegium system at the High Court level. So however, so you have to understand that in this collegium system, actually the Supreme Court judges recommend few names who are to be appointed and who are to be transferred. So the list of those judges will be sent to the executive or will be sent to the government. Okay, so the government can also raise objections because the constitution clearly says that it is the president who appoints judges in consultation with the Chief Justice of India. So therefore, when the collegium system send these recommendations to the government can raise objections over the names which are included in the recommended candidates list. Okay, so the government can raise objections and the government can also seek clarifications regarding the collegium system's choices. So whatever choices the collegium system has made, whoever the collegium system has selected for the appointment or for the transfer, the government has the power to raise such objections. And apart from that, the government can also resend, government can also send their names back to the collegium system. However, if the collegium system reiterates the names again, okay, so the government sends back the names back to the collegium system and the collegium system reiterates same names again, then the government is bound to appoint them to the respective post. Okay, so because of this reason, judiciary has a lot of powers, and Indian judiciary in fact called as one of the powerful judiciaries in the world. Okay, so this is how the appointment and transfer of judges has actually been done through the collegium system. So there are number of constitutional provisions which deal with the constitutional appointments. Okay, so there are two articles which deals with the appointment of judges. Firstly, we need to talk about the article 124 of the Indian Constitution. So what does article 124 says? Supreme Court judges should be appointed by the president. Okay, so president belong to the executive wing of the government, so Supreme Court judges must be appointed by the president, but they should be appointed by the president in consultation with the Chief Justice of the CJI of India. Okay, so president appoints judges to high courts as well as Supreme Court. Okay, so however, CJI is to be consulted in all appointments except on his or her own. Okay, the CJI must be consulted by the president before making any appointment or transfer of judges, and this is what article 124 of the Indian Constitution says. However, there's also another constitutional article, that is article 217 of the Indian Constitution. So this constitution deals with the high court. Okay, so high court judges should be appointed by the president. So here you need to understand that Supreme Court judges are appointed by the president in consultation with the Chief Justice of India. So high court judges are also appointed by the president after consulting the Chief Justice of India and even the Chief Justice of the respective high court. Okay, so and the governor as well. You need to understand this. When a president appoints judges to the high court or transfer judges from the high court, the president must consult the Chief Justice of India and the governor of the concerned state as well as the Chief Justice of the concerned high court should be consulted by the president. Okay, so these are the two provisions which actually deal with the appointment of the judges, both Supreme Court and High Court. So apart from these two provisions, there is no mention of the collegium system in any provision of the Indian Constitution. So because of this reason, we very often say that the collegium system is a judicial innovation. It does not have any constitutional sanction. Okay, so later we will understand about the National Judicial Appointments Commission Act. So that was introduced by the Indian government in the year 2014 to bring transparency and accountability in the appointments process. So however, the Supreme Court has declared the National Judicial Appointments Commission as unconstitutional and nullified the Constitutional Amendment Act. So now in this context we will briefly understand the genesis of the collegium system. Okay, so what is the basis or the genesis of the collegium system? Now the collegium system has its genesis in the series of Supreme Court judgments, right? A series of Supreme Court judgments. So it has evolved through the series of Supreme Court judgments over a period of 20 years. So the first most important case which is related to the National Judicial Appointments Commission is SP Gupta versus Union of India case 1981. So this case is also known as the first judge case. Now in this case, the Supreme Court has said that, you know, Supreme Court held that the consultation in the process of appointing judges does not require the concurrence and instead only involves the exchange of views. So this actually means that, so please understand Article 1, what Article 124 says. So Article 124 says that the President must consult the Chief Justice of India while appointing judges to the Supreme Court as well as High Courts. So therefore, in this context, the first judge's case, Supreme Court held that it does not require the concurrence of the Chief Justice of India while appointing the judges of the Supreme Court. Okay, so it does not require the concurrence, right? So this is what the first judge's case has actually said. So in the second judge's case, this is also known as Supreme Court Advocates on Record Association versus Union of India case 1993. Right, so this is Supreme Court Advocates on Record Association versus Union of India case 1993. So this case is also known as the second judge's case. Okay, so this case is also known as the second judge's case. Now in this case, Supreme Court has actually reversed its previous judgment. So in the previous judgment, what Supreme Court has said? So Supreme Court has said that there's no requirement of the concurrence of the Chief Justice of India for the president while appointing judges for the Supreme Court or High Court. So but in the second judge's case, so what Supreme Court has said that the consultation actually mean the concurrence. Concurrence means that the CGI opinion does actually matters here while appointing judges to the High Court or the Supreme Court. The opinion of the CJI is actually important. Okay, so therefore the Supreme Court has held that the advice which is tendered by the Chief Justice of India in regard to the appointment of judges of the Supreme Court or High Court is actually binding on the president. So please understand, in the first judge's case, the advice is not binding on the president. However, in the second judge's case, the advice which is tendered by the Chief Justice of India is binding on the president while making appointments to the Supreme Court or High Court. So this is what the Supreme Court has said. And further, the Chief Justice of India is required to consult with the two senior most colleagues before tendering any such advice. Okay, so when the president, while making appointments to the Supreme Court or High Courts, while appointing judges to these courts, consult with the Chief Justice of India, right? So the second judge's case says that this consultation actually means concurrence. So the advice which is tendered by the Chief Justice of India is binding on the president. Okay, so there's no doubt about that. And again, the Supreme Court has said in the second judge's case, while the CJI tendering such advice, he must consult two senior most judges of the Supreme Court. Okay, so this is what the second judge's case has actually said about the appointment of the judges to Supreme Court and High Court. Now we need to understand the third judge's case. So third judge case in the year 1998. Now in this particular case, what Supreme Court has actually said is concurrence. So consultation actually means concurrence. So president must consult with the Chief Justice of India while making appointments, and such advice is binding on the president. However, the Chief Justice of India, while tendering his advice to the president, he should involve the plurality of views of different judges. Okay, so consultation of different judges while tendering his advice to the president. So therefore, in this context, the Supreme Court has also said that CJI, Chief Justice of India, must consult the collegium of 4 senior most judges. Okay, so 4 senior most judges plus the Chief Justice of India. Okay, so total 5 members of 5 judges collegium system. So for example, in this 5 collegium system, 5 member collegium system, even 2 judges have given the opposite or adverse opinion about the appointment of the judges who are included in the list, then such recommendations or should not send the recommendations to the government. Okay, so we have understood Chief Justice of India and 4 senior most judges comprises the collegium system. So in this collegium system, even 2 senior most judges have given the adverse opinion about the names which are included in the recommended list. So then those recommendations should not be sent to the government. So however, the government, in order to bring reforms in the appointment of judges, so in order to make this the constitutional the process a constitutional process, the Indian government has brought National Judicial Appointments Commission in the year 2014. Okay, so this was brought through the amending 99 Constitutional Amendment Act. However, the Supreme Court, the 5-judge constitutional bench of the Supreme Court, has declared the National Judicial Appointments Commission as unconstitutional, and it nullified the 99th Constitutional Amendment. So stating that it has actually posed threat to the independence of the judiciary, and further continued with the memorandum of procedure. So we will understand what exactly is the memorandum of procedure in the later part of this lecture. Now in this context, the collegium system has been continuously criticized. Why it is criticized? It is criticized because in this system judges are appointing judges. Now in fact in the constitutional assembly also, members of the constituent assembly, Dr. B.R. Ambedkar, have actually criticized the appointment of the judges by the judges. Okay, so it has a certain criticism. Firstly, a lot of judicial vacancies, pending cases, is a main reason because this appointment process has been stalled because of the collegium system. Now because it has struggled to keep up with the stagnant vacancies in the judiciary, that has been leading to the pending or pendency of cases. There's a lot of cases. In fact, 4 crore cases have been pending across different courts in the country, whether district courts, high courts, or the Supreme Courts. Now in fact, if you look at the data of vacancies as of August 2022, so there are still 3 vacancies in the Supreme Court and 380 vacancies in various high courts across the country. Now after that, the other major criticism of the collegium system is it is against the system of checks and balances, right? So I hope you know what exactly is the checks and balances. So checks and balances is that there are different organs of the government: executive, legislature, and judiciary, and each organ checks the other organ so that its jurisdiction cannot be exceeded. Okay, so it cannot become arbitrary. So however, the Supreme Court has got judiciary has got a lot of powers in India, right? So it is one of the most powerful judiciary in the world, right? So therefore in this context, while appointing judges, there is no involvement of the executive, and it is against the checks and balances. It is a strict separation of the powers. However, Indian constitution has not provided for the strict separation of powers. Rather, it has provided for the checks and balances, so that the constitutionality can be protected and maintained. So since there's no involvement of the executive in the appointment of the judges, so it is against the checks and balances. So after that, there's lack of representation for women in the judiciary as well. So this is one of the main problem, and the former CJI of India, N.V. Ramana, had also talked about this lack of representation for women in the higher judiciary. So therefore, the collegium system, which recommend the names for the higher judiciary, this is one of the key problem. Okay, there's lack of representation for women in the judiciary. Okay, so the collegium system had failed to ensure adequate representation for women in the judiciary. Now if you look at the data, the Supreme Court, there are only 4 women justices out of the 33. Okay, so out of 33 judges, only 3 are only 3 judges are women judges, whereas high courts, women judges constitute around 11.5%. Okay, so around 11.5% of the judges are women in the high courts. Now after that, what can be the way forward to streamline judicial appointments in India? So we need to talk about the way forward as well. So what can be the way forward to streamline judicial appointments in India? So firstly, reforming the memorandum of procedure. Now in this memorandum of procedure, it is a way of appointing judges, the memorandum of procedure. So in memorandum of procedure, generally what happens, the Supreme Court collegium system recommend the names and send those recommendations to the government. Firstly, the law minister will forward the recommendations to the prime minister, and the prime minister advises the president over the appointment of the judges to the Supreme Court and high courts. So however, in this case, if the government has any reservations over the names which are in the list recommended by the collegium system, then the government can send back those names to the judiciary. Okay, so however, the judiciary again reiterate the names, the judiciary send back those names again, then there's no chance that only the government has only one option, that the government should go forward appointing these judges. So in this context, so we need to reform the memorandum of procedure. For example, the existing memorandum of procedure should be further reformed. So this can include involving representatives from both executive as well as the judiciary. Okay, so not just the judiciary had the larger role in appointing or transferring of judges, even the executive should also be involved in the appointment or transfer of judges. Okay, so in the decision making for judges, so therefore it results in checks and balances in appointment of judges, right? So after that, increasing diversity also. Now if you look at the social composition, the social composition of the judges across different high courts and the Supreme Court, the judges from the other backward classes, SCs, STs, is very low, very minute. So therefore we need to increase the diversity. There should be more women judges in the judiciary apart from judges from these backward classes. So therefore we need to focus on providing adequate representation in judicial appointments, and this is another step that has to be taken. So after that, the other major thing is that increasing transparency and accountability of judiciary. Now this is very important. The National Judicial Appointment Commission has brought into light to increase transparency and accountability of the appointment of judges. So however, in order to increase transparency, what needs to be done? Okay, so a list of candidates who actually applied, nominated by the collegium system or recommended by the collegium system, or considered by the members of the collegium system, should be maintained. Okay, so this list should be maintained, and in this collegium system also the members or the judges have different opinions, so they have to record those opinions in writing. So even they can think of putting those recommendations in the public domain, so that there will be more and more transparency and accountability in the appointment of judges to the higher judiciary. So after that, the proceedings of the collegium system should also be documented and recorded in the minutes. So this also ensures more transparency and accountability. So however, ultimately, in the guise of protecting judicial independence, judges should not be appointed by the judges. Okay, so that is against the constitutional principle of checks and balances. Okay, so therefore in this context, there should be active involvement of the executive also in the appointment of the judges, and appointment of judges should be done in a more transparent manner. There should be accountability in the appointment of judges. So in this way we can reform the appointment process, and we can also reduce the instances of corruption, and we should also focus on diversification, appointing more women judges, and diversification of the judges from different communities, and also appointing more and more judges, so thereby filling up vacancies and reducing the pendency of cases. That is actually good for the Indian judiciary going ahead. So that's all about the collegium system. Thank you.